Question I guess I have. You have to jail up?
From the opening seconds, this hearing already feels unstable. Judge Simpson barely starts the session before everything derails, and what you're about to see is one of the wildest displays of courtroom defiance you'll ever witness. This isn't just a routine procedural hearing. This is a judge trying to maintain control against a defendant who repeatedly tests every boundary he can find. The tension is already brewing. Mr. Bloom is supposed to appear via Zoom, per the court's last order, but he's refusing again. That refusal isn't just inconvenient, it has legal consequences tied directly to his right to be present, his ability to assist his attorney, and whether proceedings can continue without him. This VO sets the stage for the entire case. A defendant who believes he can negotiate the rules of the courtroom, and a judge who reminds him, repeatedly, that the law doesn't bend to personal preference. Watch how quickly this situation escalates from simple non-compliance to outright courtroom chaos. And ask yourself, is this defiance, fear, strategy, or self-sabotage? Because throughout this hearing, you'll see moments where Bloom's choices directly shape the judge's patience, and eventually, his fate. This is the setup to a volatile session that only gets more explosive. Buckle in.
Okay, we're on the record in the Bloom matter. We were waiting for Mr. Bloom to appear via Zoom since that was the court's last order. I have now been informed Mr. Bloom does not wish to participate via Zoom. So we're going to have a problem. And it's not going to be my problem. You may.
When we heard the last hearing, I understand my client had several offers for the court removed him from the courtroom, but she also gave me a chance that if I could rehabilitate him, that he could be present in the courtroom. Now, I met with Mr. Bloom. I believe he's rehabilitated. I would ask that he be allowed to be in the courtroom. Things have changed.
Let me just say this. I'm not going to have Mr. Bloom try to control these proceedings. That's my job. And so if Mr. Bloom wants to be part of this proceeding, then Mr. Bloom will appear via Zoom. If you want to then make your argument for him being in the courtroom, you may make your argument at that point. But if he is refusing to participate as the court has directed, I have an option. I can proceed without him. He has forfeited his right. Or I could adjourn it out till he is fully rehabilitated and understands how this court works. Those are really the options, Mr. Kilmo. I'll let you say what you want to say, but those are the options.
Your Honor, I met with him last night. Things have changed somewhat drastically in that Ms. Blaisdell is not going to testify to this. She has COVID. So we only have one officer who's going to testify to the other case, the obstructing the officer's case.
This section reveals another layer of tension. The prosecution is prepared, the officer is ready, and everyone expects the hearing to move forward. Except Bloom. Procedurally, this matters because hearings are structured around witness availability, scheduling, and statutory requirements. When a defendant refuses to participate, it doesn't just disrupt the flow, it risks wasting official time, delaying justice, and frustrating witnesses who rearranged their schedules. Notice how the defense hints that Bloom promised to behave, promised to abide by the court's rules, yet didn't follow through. That contradiction is a recurring theme. Bloom says one thing, does another, and expects the court to adjust. Judges see this pattern often, and Simpson clearly has no intention of playing along. Think about it. Should the court give a defendant another chance when previous chances were wasted? Or does repeated non-compliance justify strict action? Simpson's calm but firm tone shows he's nearing the point where patience ends and consequences begin.
Again, I met with Mr. Bloom last night. He gave me tons of notes, which I reviewed last night. I expected him to be by my side. You know, I asked if he was rehabilitated. He said he would abide by the court's ruling. He was rehabilitated. I again am asking that he be present in the courtroom today.
This court will not be held hostage to Mr. Bloom's antics. Doesn't work that way, Mr. Killowell. You know that.
Judge, I understand that. But what I'm saying is, can't you give this man a chance? I say he's been rehabilitated.
Whoa. When he was in this courtroom, he had like 8 chances. I didn't kick him out the first 5.
I agree with you.
And ultimately, it got to the point where he had to be removed. Then once removed, so that everything else is clear, he was fine for about the first 45 minutes. And then all of a sudden tells an absolute fabrication to the court to try to get himself back in here, saying he can't hear. Problem is, he didn't know there was a deputy behind him. I asked the deputy, and the deputy, he could hear clearly. I'm not playing his game. This will get done with or without it.
This is a turning point. When a judge openly states, "I'm not playing his game," it signals that the court recognizes manipulation and is formally refusing to entertain it. This isn't personal, it's procedural. A defendant who disrupts, lies, or refuses to comply forfeits rights because the system cannot function otherwise. Bloom's false claim about not hearing the proceedings, exposed instantly by a deputy, is significant. Misrepresentation to the court is serious. It undermines credibility and damages every argument the defense attempts moving forward. Judges don't forget moments like this. Something else stands out. The judge recalls Bloom being given 8 separate chances in the courtroom before being removed. 8. That's far beyond typical judicial tolerance. Most judges remove a disorderly defendant after 2 warnings, sometimes even 1. Simpson's memory of Bloom's behavior fuels his decision today. Viewer question: how should a judge balance fairness with courtroom control when a defendant consistently disrupts the process? This is no longer about one hearing. It's about a history of behavior shaping judicial trust.
I'm not asking you funny games, Judge. What I would say is, I don't necessarily disagree with you last time. Would you give this man a chance one time, and or give me a chance to go down to the jail? Again, Your Honor, I thought he was going to be by my side today on a short matter with one of the police officers, Your Honor. I either have to give me a chance to go down to the jail and talk to him and explain what's going on, or bring him into the interview room so I can at least tell him what's going on. I think he deserves a chance.
You got half an hour. You can go down to the jail.
Pardon me?
You can go down to the jail.
Thank you, Your Honor.
Court is standing in recess. Sorry, folks. Court calls cases of the people of the state of Michigan versus Bloom.
Good afternoon, Your Honor. Good afternoon, Judge Bloom, Your Honor.
All right. And Mr. Kilowald, your conversation with Mr. Bloom.
Your Honor, I had a chance to speak with Mr. Bloom. I explained to him that he will not tolerate any antics or any outbursts. He said that he would be willing to abide by your court rules, and I'm asking you to reconsider or barring in the courtroom and give this man one last chance. I do need him for his guidance and management when the officers are testifying. So I should reconsider the decision. I believe Mr.
Well, Mr. Bloom won't even get on Zoom for my decision.
Well, Your Honor, this is tough for me to say. He said he would not do it by Zoom. So I said I would ask the judge to allow me to appear in the courtroom.
Do the people have a position?
At this point, the prosecution's tone shifts. They see exactly what the judge sees: a defendant who has been given every opportunity to participate and chooses disruption instead. When the state signals readiness to continue without Bloom, it aligns with procedural rules allowing the court to proceed in absentia if the defendant refuses to comply after being warned. This is important legally. Courts must show they made reasonable efforts to include the defendant. Simpson has done that, repeatedly. Bloom's non-participation becomes a choice, not a deprivation. The defense's frustration is clear too. It's hard to represent a client who won't listen, won't follow directions, and won't appear. Cross-examining witnesses without your client is never ideal, but courts cannot stop functioning because one defendant continually rejects procedure. Viewer reflection: is the system failing Bloom, or is Bloom sabotaging himself? This moment foreshadows the explosion that's coming, because Bloom is about to re-enter the conversation and everything spirals.
In the court's discretion, I did indicate to counsel and your staff earlier that we are not able to proceed on a continued CSC exam because that's the test testimony or anything like that. But we are ready to proceed on Deputy Vice President.
Mr. Coolwald, I gave your client a number of chances and he's just playing a game with this. So I'm just not going to bend on that.
Your Honor, again, I have to object to the ruling for what that's worth. It's hard for me to proceed without a client. So
You did just fine with cross-examination of the witnesses when he was removed for his behavior.
I understand, Your Honor, but I believe my client has been rehabilitated and deserves at least one chance to be in the courtroom. I don't expect you to put up with any answers. I told him any outbursts you're out.
So keep
He
your
deserves that chance.
So he's there ready to sign it. Is it shut off? Did we remove that at some point?
Here, Bloom begins unloading a long, emotional monologue, and this is where the entire courtroom energy shifts. He refuses to turn on his camera, argues about Zoom rights, claims witness sequestration violations, and even predicts future legal precedent. None of this aligns with actual courtroom procedure. This is classic narrative flooding. A defendant overwhelms the record with personal claims, perceived injustices, and irrelevant grievances to derail the proceeding. Judges see this often from defendants who feel unheard. But the problem is, volume doesn't equal validity. Bloom's refusal to appear on camera is extremely significant. Courts require visual identification to ensure the person speaking is the defendant. Refusing video is refusing participation. His accusations, corrupt doctors, falsified COVID tests, witness manipulation come with no evidence, and Judge Simpson knows it. Think critically. Is this desperation, paranoia, or an attempt to cloud the record for appeal? Bloom's monologue is emotional, chaotic, and self-damaging, and the judge is losing patience rapidly.
No, not to.
Hello. You're muted, Judge.
I am. Hello.
Hi.
Is Mr.
He is here.
Okay.
He's claiming that he's not going to come in because it's on Zoom.
And my attorney advised me that if I didn't have a preliminary, that not to do it on Zoom, so.
Well, so that the record is clear, I had removed this defendant from the courtroom, had advised counsel that we would be proceeding by Zoom. So he's going to have to make a choice of the choices I gave you, Mr. Kill. And that is that he can either decline to participate and we will proceed, or he can participate by Zoom. Those are his options.
So I can speak. So can I speak?
Go ahead.
If you want to, Mr. Bloom.
Mr. Simpson,
That's Judge Simpson, and you'll need to be on camera.
Your Honor, I don't have to be on camera. I refuse to be on camera because Mr. Kilwald, I don't mean any disrespect, Your Honor. I think you're a highly, highly efficient, very intelligent judge that has been around here a long time, and as well as you know I have. My qualm with this is because Zoom, at the last hearing, Zoom was broadcast over the internet where the other victim and witnesses that weren't at the court weren't sequestered like was supposed to be. And it was on Zoom, which I'm aware there isn't an MCL number yet, but I'm sure within a year or two, there will be something precedent to where it's not allowed anyway, because I asked for a in-person sequestered witnesses and that didn't happen. I was violated. My rights were violated. I feel my rights were violated. And my attorney this time, I don't mean to take up time. Your Honor, I have anxiety and I've been really stressed out because as will be shown in the long run, no matter how many felonies I've got, no matter how many times I've been to prison, I will be exonerated from these crimes. There's no doubt in my mind. And I believe, honestly, that the reason that the victim did not, or the second victim, supposed victim, didn't show up for court and said she had a positive COVID is because a crooked doctor in IFSI gave her a positive COVID because she's on drugs and alcohol because she gets $2,200 a month and she's very addicted. She's very strung out. She cut her tether off. They're not making her get treatment. They know she drinks a half gallon of vodka every day.
Okay, so
This is where Bloom's statements cross from emotional into dangerously speculative. Accusing a victim of drug addiction, bribery, falsified tests, and refusing treatment without evidence is not just improper. It undermines his credibility and risks further sanctions. Courts operate on verifiable facts, not speculation. Simpson cuts him off for a reason. Defendants cannot turn hearings into character assassination sessions. The judge's intervention protects the integrity of the proceeding and keeps the focus on admissible information. Bloom's frustration feels real, but his method is self-destructive. Instead of strengthening his defense, he's giving the judge more justification for restrictive measures, including denial of in-person participation and increased contempt risk. Viewer engagement moment. If you were the judge, would you allow Bloom to continue speaking, or would you intervene exactly as Simpson did? Simpson has heard enough, and the hearing is about to take an even sharper turn.
so
Jeffrey, this is your turn.
This
Okay,
is-
all right, I'm done talking about that. What I have to say, Your Honor, like I said, I've got the utmost respect, and I've heard you are a very fair judge, very qualified to do your job, and that you have seen through the crack, okay? And you know what goes on in IFSI, and you know what's going on in them streets. So I'm letting you know now, though, that as my attorney said to you, I will be perfectly fine if you allow me to come back into the courtroom. But he advised me that maybe I shouldn't do this on Zoom. And I do feel myself that yes, I made a mistake. But like I said last time, I was put on Zoom when I shouldn't. I wasn't even aware until I was kicked out of the courtroom that I was on Zoom, and that the witnesses were able to leave the courtroom and go out and talk to the other witnesses and pull up Zoom when they get home and show them, this is what I said. Now you need to follow along with this. Then you got the police officers going to arrest her.
Mr. Bloom,
Bloom's argument here becomes circular. He insists witnesses coordinated testimony through Zoom, despite having no proof and despite the judge and officer confirming sequestration procedures were followed correctly. This is a pivotal moment because it highlights one of Bloom's core misunderstandings. Belief is not evidence. Courts require verifiable facts, not suspicions, theories, or imagined misconduct. Judge Simpson finally steps in with a firm correction, telling Bloom he has no idea whether any of what he's alleging actually happened. That's not just a rebuke, it's a judicial warning. When a defendant repeats unverified accusations, especially accusations that attack the integrity of witnesses, officers, or the process itself, the judge must intervene to protect the court's legitimacy. Bloom's attorney tries desperately to stop him, knowing every additional sentence damages their case. Defense lawyers dread moments like this. A client publicly unraveling while the judge watches. Ask yourself, is Bloom trying to defend himself, or is he letting frustration override strategy? The hearing's temperature rises sharply here. The judge's patience is nearly exhausted.
you don't know any of what you're saying even happened.
I don't.
Jeffrey,
Mr. Kilwald informed me.
Jeffrey, this is your attorney. Please stop talking. You're just making matters worse.
Okay, well, Mr. Kilowald, I put things in your hands.
And I'm going to ask the judge if we could do this hearing without Zoom. That's the judge's discretion.
And I said to the judge, Your Honor, I promise you, I will be cordial. I will be polite. I will not. I had a cold last time, so I did make a couple little snide remarks or whatever. And maybe it was your discretion. So, but the thing is, Your Honor, I don't mean to carry on, but use your judgment, Your Honor. And if you don't want me to be there, I have trust in my attorney that he will get the copy of the COVID test. He will get all the evidence needed to show that this victim did not show up for court because she does not want to show up for court, whether the police wouldn't does it or not.
Mr. Bloom.
The judge interrupts Bloom because he's repeating himself, escalating accusations, and misrepresenting facts. Notice how Bloom treats assumptions as conclusions. claiming the alleged victim intentionally avoided testifying, asserting corruption, painting himself as the target of systemic misconduct. But the judge knows the reality. An officer verified the COVID diagnosis, documented it, and was prepared to testify under oath. That's real evidence. Bloom's emotional state is spiraling. He apologizes, compliments the judge, and then contradicts himself again, all within minutes. This oscillation between praise, accusation, and frustration is exactly what raises judicial concern about reliability, self-control, and courtroom safety. Simpson isn't rude, but he is firm. Bloom's conduct, not his words, determines how the court proceeds, and the judge reminds him that participation is optional, but consequences are not. If a defendant's behavior jeopardizes their own case, should the court intervene more aggressively or let the natural consequences unfold? Bloom is losing ground quickly, and the judge is preparing to take control.
From my understanding, although I have not heard from them yet because we were waiting for you to get here, there's an officer here who arrived to get the victim in this case.
Supposed victim.
And no, he arrived to do that.
To get a supposed victim, not a victim.
Okay. I've listened to you talk without
Thank you.
interruption, and now you're listening to me.
Yes, sir. Yes, Your Honor.
And the officer saw the COVID test, from my understanding.
Did he take a picture?
I don't really care whether he took a picture. If I put him, if he's going to tell me that that's what he saw, that's what he saw.
Okay.
And so that's not going to happen today. The other case that you're here on is prepared to go. Now, you can elect to participate or not, but I think you need to understand something very clearly, Mr. Bloom.
Yes, sir.
You do not make the rules. You will not sit here and say that somebody is violating your rights, that I guess being me, in some type of extortion to get your way. Wrong judge, wrong day, because it doesn't happen with me.
Well, I'm sorry you see it like
Plain,
that.
plain and simple.
I'm sorry you
Just
see it
plain
like
and simple.
that, but it's not. That's not what I'm trying to articulate to you. Not at all.
So I just asked, and these are the rules that were set because they were set because of Mr. Bloom's behavior. So I will again pose the question as to whether or not Mr. Bloom wishes to participate. If he doesn't wish to participate, he doesn't have to participate. That's his call.
Your Honor,
But my intent would be to go forward.
Your Honor, on behalf of my client, again, you've heard him saying that he apologized to Your Honor. He would like to be present in the courtroom. I would ask the judge to reconsider, I believe, and relocate it. If not, I would ask that it not be broadcast on Zoom, which again penalizes my client, but I don't know what else to do.
I am not going to deviate for anyone from what has been this court's procedure. It will broadcast on Zoom. If necessary, it will proceed, or it will broadcast on YouTube. It will proceed.
Really?
This is one of Judge Simpson's strongest declarations of authority. He makes it unmistakably clear that the proceedings will continue, broadcast publicly, and follow established courtroom procedures, regardless of Bloom's objections. Transparency is not optional in most criminal proceedings unless specific statutory criteria warrant closure. Bloom's request to shut down public access was legally baseless, and the judge calls it out. But then comes the explosive moment. Bloom accuses the court of corruption and rights violations. That line, "You're corrupt," is the red line no defendant should ever cross. Judges rarely react emotionally, but personal attacks on judicial integrity trigger immediate consequences. Simpson wastes no time, 93 days for contempt. This is a critical educational moment for viewers. Contempt isn't about hurt feelings. It's about maintaining order and respect for judicial authority. Bloom's outburst directly threatened that order. Ask yourself, should contempt be immediate in moments like this, or should the judge have given a warning? Simpson chose firmness, and in this courtroom, firmness is survival.
Just please note my objection to my client.
I've noted your objection. I saw the email that was sent indicating that your client requested that the courtroom be closed without any statutory authority whatsoever to close the courtroom.
Your Honor, you're allowing
And
the
that-
witnesses and the victims to see each other's testimony on Zoom. You're allowing witnesses and victims to see each other's testimony.
Your Honor, to Ms. Reiser's credit,
With-
I believe she did cite a court statute that would allow you at your discretion to close.
And my discretion doesn't mean that I will, and I'm not closing the courtroom. I'm
Well,
not.
then you're corrupt. You are in violation.
Oh, that's it. You're in contempt. That'd be 93 days. Anything else you want to say, Mr. Bloom?
Thank you, Your Honor. Mr. Kilowald, you can handle it. Thank you. Goodbye.
Thank you, Jeffrey. I appreciate that.
Just for the record, and I would like to indicate for the record and for counsel in the court, at the September 13th preliminary witnesses were sequestered. So
I know.
when Mr. Marshall was testifying, Ms. Blaisdell was sequestered outside the courtroom. She had no access to any electronics, so there isn't any way feasible for her to have watched or seen Mr. Marshall's testimony. So the witnesses were sequestered and the officer in charge is present in the courtroom.
Your Honor, just very brief on that. We had a few breaks during, I think what my client is getting to, we had a few breaks during that time.
I can't even hear it. I can't even hear it. This is Nazi. This is Russia. I can't even hear what the prosecutor or my attorney are saying.
Bloom again claims he cannot hear, but notice how both the judge and his attorney respond. Neither accepts the claim as credible. The judge even checks with the prosecutor and others present. Everyone else hears clearly. This mirrors Bloom's earlier false claim about audio issues, a tactic the court already caught. At this point, the judge has to weigh two possibilities. Bloom is experiencing genuine technical difficulty, or Bloom is using audio complaints to derail the hearing again. Given Bloom's history and timing, the judge leans toward option 2. Judicial decisions don't occur in isolation. They consider patterns. In legal terms, Bloom's objections lack foundation, and his emotional outbursts further erode credibility. His comparisons to Nazi or Russia courts reveal the emotional desperation overshadowing his legal strategy. Does Bloom genuinely believe he's being silenced, or is he using exaggerated language to provoke a reaction? The courtroom atmosphere is reaching peak volatility here.
Mr. Marshall Brown was allowed to leave his stand, and I believe my client believes when he went out, he may have discussed that with the other witness. I think that's what my client is referencing. Just for the record.
This is corruption. I can't even understand what they're saying. Can you hear it? Can you understand it? Don't worry.
So the witnesses were sequestered at the September.
I know. The witnesses were sequestered at the last hearing. The witness was not in the presence of the other witness while they were testifying and did not have access to electronic devices in which to hear the testimony. And I heard that very clearly, and I recall that happening. The revisionist history that's trying to be placed on the record wasn't what occurred.
And in terms of going forward in 22 FB 1278, I do have Deputy Mace who is present today. The victim does not have transportation, so the Sheriff's Department was picking her up for the preliminary exam today. The second victim that needed to testify, Tiffany Blaisdell. She does have COVID. Deputy Mace made contact at the residence, saw the paperwork, so I'm happy to put him under oath to put that on the record. The positive COVID test that she had.
So she had a positive COVID test, and so that I'm clear, the positive COVID test was from a clinic or doctor or something along those lines.
Hospital discharge paperwork from Sunday, October 2nd, 2022. Correct.
With all due respect, we have the officer here. Can you please get on the stand and testify that I know Ms. Ryder, but she's just repeating what the officer could be saying under oath for the record, Your Honor.
In this wonderful world we're in, dealing with COVID every day, an officer's going to come report to the prosecutor that the alleged victim in a case has COVID and sees paperwork that's reported to you, and somehow or another that's going to be questioned.
Yes, Your Honor.
You got to be kidding.
No, Your Honor.
Let's do this. No, Mr. Killawald, it's your bed. You're going to lie in it. Officer, please take the stand. If you come forward, be sworn.
The other witness needs to question, Your Honor.
For the testimony on COVID?
Fine. I withdraw my report.
The two officers are present
Are on the other case. This is about the,
CSC.
right. Let's have him sworn.
Raise your hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, and help you God. Lower your hand, have a seat. State, spell your first and last name for the record.
Yep, Deputy Sean, SDAN, that's administrative.
Sure.
Can you tell the court where you're employed, sir?
Washington County Sheriff's Office.
And in what capacity?
Deputy Sheriff.
And were you working today, October 4th, 2022?
Was,
And what was your second?
patrolling the Land Township.
And were you sent to Osmond's Way to pick up a victim on a case that you were there?
Correct, I was working informer that she had court today, a reminder that she had court today, for transportation.
And did you do that?
Yes, I did.
And did you make contact with Ms. Blaisdell?
Yes, I did.
And what, if anything, did she advise you?
Yep, when she came in the door, she advised me that she couldn't do the court date because she had COVID. She showed me hospital discharge paperwork dated October 2nd, 2022. Paperwork is in the she had COVID.
That was October 2nd.
2022?
Sure.
And you saw that paperwork?
Yeah.
Okay, and how did she appear to you?
She appeared sick. She was coughing profusely. She sounded nasally.
Thank you. I have another question.
Cross-examination.
Yes, Your Honor. Also, just a couple follow-up questions. Is there a reason why you went to pick her up?
Yep, I was arrested by search warrants.
Do you know if she owned a vehicle?
I'm aware.
Okay. And how is it that you interacted with her? I mean, is she COVID right now? I mean, does she have COVID right now?
This moment solidifies the factual basis supporting the adjournment. The officer's testimony is clear. He saw the victim in person, verified her condition, reviewed discharge paperwork, and observed symptoms consistent with illness. That level of first-hand observation carries significant weight. The judge no longer needs to entertain Bloom's theories about falsification, conspiracy, or collusion. The evidence speaks louder, and Simpson reinforces this by confirming key facts directly. The date of diagnosis, the witness's condition, and the absence of any reason to doubt the officer's credibility. This is a strategic blow to Bloom's narrative. Everything he argued earlier, corruption, avoidance, intoxication, manipulation, collapses under the weight of sworn testimony. Viewer reflection. When credible evidence contradicts a defendant's emotional claims, should the court prioritize efficiency or allow the defendant further opportunity to dispute? Simpson chooses efficiency, and that decision shapes the rest of the hearing.
And if so, I'm wondering how you approached her or discussed with her.
Yep, I knocked on the front door. She came in the door, and I spoke with her at a distance.
Okay. And she showed you some paperwork?
Correct.
And what was the paperwork that she showed you?
It was hospital discharge.
And from what hospital?
Trinity Health.
I'm sorry?
Trinity Health, St. Joe's.
Trinity Health? And did it show a doctor's name on there?
I don't know.
You don't know? Did you take a picture of that with your cell phone?
Did not.
Did Blaisdell appear in any way intoxicated or under the influence of drugs?
No, she didn't.
And how long have you been in office?
1 year.
Thank you very much. I have no further questions.
All right. So that the record is clear, sir, you went to the door. She said she had COVID. You saw paperwork that indicated that she had COVID from a diagnosis or at least a discharge from St. Joe's Hospital of October 2nd. Correct. And as she appeared to you, she was coughing, nasally sneezing. did you have any reason whatsoever to doubt that what she was telling you was true? All right, thank you. You may step down.
We would request a continuance in 22 FB 1278. The court's next available date. I don't know what the quarantine is now for the CDC, making at least 5 days at the thing.
Well, yes, kind of, but I don't know that we're going to be able to get you in 5 days.
Right.
So I don't think that's our issue. Our issue is going to be more finding a date. Whatever. So in 1278, preliminary examination is adjourned to November 1st, 2022, 1 p.m.
And we are ready to proceed in 22 FB 1276, and then we have Deputy Bob, OIC, to my left, and my first officer, probably Deputy Trevor.
Okay, hold on one moment. Mr. Kilowald, your client has, I guess, determined not to participate. How would you like to proceed, sir?
Your Honor, I've made my objection of him not being in the courtroom. I don't know what else to do, Your Honor. I guess I could object to this hearing further if he's not participating. I'm supposed to advocate on his behalf. I would say I understand that he said I can't be in the courtroom.
Now we see the defense attempting damage control. Bloom has chosen not to participate. The officers waited all afternoon, and the judge is juggling disruption with procedural fairness. The defense wisely argues for the court's patience, hoping to prevent deeper consequences for Bloom. Simpson, however, is done compromising. His explanation is crystal clear. Bloom's behavior today eliminated any possibility of returning to the physical courtroom. The judge even explains that future participation will require a written motion, one Bloom must adhere to, not rant through. And even then, Simpson is predisposed not to grant it. This isn't punishment, it's risk management. A defendant who repeatedly disrupts creates safety risks, procedural delays, and unfair burdens on witnesses and officers. Viewer engagement? Should Bloom lose the privilege of appearing in person after violating expectations repeatedly? Or should courts try harder to keep defendants physically present? The judge's ruling marks a definitive shift. Bloom is now a remote participant by necessity, not choice.
He's still on patience with him, Your Honor. I need to attorney. I can't listen to him tell him I was asked to report during this matter.
As they have sat down here all afternoon, would the officers be available on that November 1st date?
So they are both available that day, but so we definitely, they're on their shift right now, so we have half of the Ipsy Township patrol has been sitting in court for 3 hours. So my preference would be to finish it, do it today. I mean, we'll be kind of running into the same situation again on November 1st.
I don't know if we'll be running in. I mean, with them being here, I get that. I don't know if we'll be running into the same circumstance, but I'm sure, as you can appreciate, given Mr. Bloom's outburst, I'm trying to balance things and what Mr. Kilowald has said. So I am going to adjourn the proceeding. What I will do, however, so that my order can be clear, and if Mr. Bloom at that time elects to do what he has done today and not to participate or participate from afar, that's going to be his choice. I've given, as I said at the end of the last proceeding, I would certainly reconsider allowing him back in the courtroom. However, that is off the table at this point, because he has shown by his behavior today that he cannot conduct himself appropriately. So his choice will be that he can participate via Zoom, or he can elect not to participate at all, and we will continue with the proceeding with him in absentia. He has plenty of time to attempt to try to gather an understanding as to how this court is going to operate. And so if he has time to figure out what his decision is. If there is a request, Mr. Killewald, well, so I'm making it clear that's where this court is going. If there is a decision that he wishes to do that, that will need to come by written motion to me as to all of these supposed promises that he's making as to how he will conduct himself. But that doesn't mean I grant it, and right now I am predisposed not to.
You're saying he wants to be in the courtroom, I have to file a motion.
Absolutely, because my ruling now is that he will not be in this courtroom.
And it's my understanding he gave him, contempt.
I held him in contempt, summary contempt, 93 days.
Is that something I can argue in the motion? Or?
If you'd like to, you may, but you can argue whatever you'd like.
Thank you, Your Honor.
So, and to the deputies, this court doesn't like to waste time, but I apologize to you for the delay and not being able to go forth today. But I think you also can appreciate I'm trying to balance certain things here.
Judge, should I just ask one other question? Is there, and again, I probably, let's say ask this, but is there another possible day in that later in the week in case my trial goes that we could have an alternate day that's set, that if my trial goes, it should be done by Wednesday?
Later in the week?
Yes, no.
Okay, so later in the week, that's not going to happen.
Okay.
My Wednesday is full of townships things. My Thursday is full of every PCC, which you know, and my Friday would be full of a housing docket. So that's not going to happen. It's going to have to be a Monday or Tuesday. That's the only way it will happen.
Could we set an alternate date for the, and again, I apologize to everybody, but could we set an alternate date of November 8th, Your Honor, or Tuesday?
All right, November 7th, 2022, at what time you want me to do it? At 9 a.m. And so, Mr. Killewald, you're requesting that both hearings be set to that time.
Yes, Your Honor, and I do appreciate everybody's consideration, especially the officers. I do apologize. Now that I said, hopefully my trial is off, but if it doesn't, it's November 7th is perfect for me.
At 9 a.m.?
Yes, at 9 a.m. It'll be in the morning.
November 1st. Thank you, Your Honor, and I will anticipate giving you a motion within the next several weeks.
I will look forward to reading it. Folks, thank you. And again, to the deputies that took their time, my apologies. All right. Is that it for us? Those are my notes. 14A stands adjourned.
This concluding moment wraps a hearing defined by conflict, defiance, and judicial firmness. Judge Simpson did everything procedurally required, and more, to accommodate a defendant who consistently refused to cooperate. The court gave Bloom chances, warnings, recesses, and options. In return, Bloom offered accusations, interruptions, escalating hostility, and ultimately an outburst that resulted in a 93-day contempt ruling. Key takeaways. The court can and will proceed without a defendant who refuses lawful participation. Zoom proceedings are valid unless statute or judicial order dictates otherwise. Witness sequestration was properly handled, undermining Bloom's claims. Officer testimony provided credible confirmation of the victim's COVID diagnosis. Bloom's repeated disruptions directly contributed to the judge's final decisions. In the end, This case demonstrates how courtroom authority functions under pressure and how quickly a defendant can damage their own position through emotional, unrestrained behavior. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.